Hello, this is Matt on the Moon Lambo channel. The deposition of former SEC Director William Hinman is occurring today, July 27th. In fact, at least at the time I'm recording this, just a couple hours or so from now. And I wanted to share with you what to expect because, unfortunately, this is a private deposition. So, indeed, William Hinman will be under oath. He will be heavily questioned, no doubt, by Ripple's legal team, their attorneys. But this isn't like a pretrial hearing that many of the past you've been able to call into. This is private. Unfortunately, we're not going to be able to hear this. Now, in the future, it's highly likely that we'll get some pieces of what was specifically discussed. I think some of that will come out, and I'll talk more about that a little bit later in the video and why that is. But thankfully, John Deaton, who is an attorney within the XRP community, he is in fact the attorney that's seeking to intervene in the SEC versus Ripple case on behalf of over now 19,000 XRP holders. He has shared what his expectations for this deposition is over, well, on a number of different occasions, including interviews I've seen on YouTube as well as on social media, specifically Twitter. And so what I've done is I went ahead and compiled a bunch of his thoughts on what to expect on this, and then I want to share that with you, while of course being sure to give credit where it's due, because yes, I'll share with you my opinions along the way, but John Deaton's the one with the legal background here, and he really broke down like how Ripple's legal team can actually turn William Hinman potentially into their star witness. That's what John Deaton said. This could potentially go very well, and so I want to talk a bit about the implications of that and what the line of questioning you might expect to what that might look like coming from Ripple's legal team. But I do want to be clear at the outset: I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who likes making YouTube videos as a fun hobby about Ripple and XRP and crypto in general, but that is all that's going on here. And so I typed up a ton of notes and printed them, so I'm just going to go through them now. Check this out. And so William Hinman, John Deaton says, will be questioned about the $15 million that he collected while he was at the SEC from his former employer and the conflicts of interest as a result of this. And so he'll simply be asked, why give a speech about Ethereum specifically in the first place? What is the intent if not personal gain? Did the fact that your former law firm is on the board of the Ethereum Alliance, did that factor into this decision? Did the fact that your former law firm has clients with interests in Ethereum factor into this decision? And so for those of you that are unaware, William Hinman, while he was working at the SEC as a director, he was getting paid by his former employer, law firm Simpson Thacher. He just made millions and millions and millions of dollars while he was setting policy effectively that benefited his former employer. Then when he left the SEC, he went to go work for them again. What in the ever-loving hell is that? The optics are not good, at a minimum. I'll just say that the optics not good for Hinman. And so John Deaton thinks, yeah, Ripple's legal team gonna be asking about that. Now, Hinman may testify that he doesn't remember much of anything in an attempt to evade truth and justice. And if he goes that route, though, the judge will likely see it as an evasion tactic and that'll play to Ripple's benefit. But you never know. And so Deaton says that Hinman could end up being Ripple's star witness. And as I go through further, you'll see exactly why John Deaton said what he said on that topic. And so everyone now knows that Hinman met with one of the co-founders of Ethereum just 1 week before he gave his speech in 2018. It was June 14th, 2018. That's what's on your screen right here. This is the speech. He 1 week before giving the speech, he met with a co-founder of Ethereum right here. And we're not sure which one, though. Was it Vitalik? Was it... I don't know. I'm not sure who it was. But Ripple's attorneys will ask, what was discussed during your meeting, right? Did it impact your Ethereum speech? Did he, whoever this Ethereum co-founder was, did he get a draft of your speech? And if so, did Hinman ask for feedback to ensure he wasn't saying anything incorrect about Ethereum or its technology? did the Ethereum co-founder write any of the speech? So these are the types of questions that John Deaton is saying, of course, Ripple's legal team is going to be asking. And you'll see why these questions are important. Just hang with me in this video because we got to talk about what this means for XRP, and I promise I'm getting to that. Excuse me. Now, Deaton says Ripple's attorneys will ask, the who, what, where, and when, type of questions. And this is because Ripple can't ask questions regarding privileged information. And so, for example, they could ask how many drafts of the Ethereum speech were there, who took part in writing the speech or approved of the speech. And by doing that, you're not asking for privileged information since you're not asking what the people involved with the speech specifically said. And so Deaton says Ripple's lawyers should ask if any of the 5 SEC commissioners reviewed the speech before he gave it. And so, if an SEC commissioner such as Hester Peirce, for example, gave the speech, this is important because we know what her current position is on clarity within the space, right? We know that commissioners Hester Peirce and Elad Roisman wrote a public piece, which was published on July 14th this year. It's on the SEC website, and they're citing that there is not and never has been regulatory clarity in the crypto space. And so when Hinman is under oath, Deaton says if it were him, he would definitely want to know if they reviewed it. Due to privilege concerns, you wouldn't be able to ask what they specifically said about the speech back then, but we do know what they say today about the lack of regulatory clarity. I covered that very thoroughly in a separate video, so I'm not going to break that down in this video. But they did not mince words. They made it very clear that there absolutely is not sufficient regulatory clarity in the crypto space. And so we know what they were likely to have said in 2018. It would not likely be the case that in 2018, Hester Peirce and Elad Roisman, 2 of the 5 commissioners that decide whether or not to bring legal action against any person or business, it's not likely that, in 2018 they believed there was clarity, but their opinions changed in such a way that they no longer believe there is clarity. No. It's the whole time, clearly, they've not thought there is clarity. And this is important, especially given the specifics of his speech. And I'm going to run through, sit tight, you're going to love what's coming up here, especially in the later half of this video, I think, because I'm going to run through some of the specifics of this speech that John Deaton commented on and share with you what he had to say about this. And so anyway, the SEC is claiming Hinman's speech was only about his personal opinions and not an official stance of the SEC. Okay, well, if it's only his personal opinions, why would what someone told him be a part of the deliberative process of the SEC? Right? That makes no sense. And so claiming privilege is a bogus argument if the speech really has nothing to do with the SEC itself. Now, as far as a legal tactic, though, to what degree that's going to prevent him from having to answer important questions, we don't know. We're not sure, but still, it's bogus either way. And I'm not. Look, let me walk back a little bit of that. There could be things that could be asked for which there's a legitimate claim to privilege. I'm just saying that I suspect that the SEC and William Hinman are going to try and use privilege as an excuse to not answer legitimate questions. That's what my concern is, and so we shall see. But again, like John Deaton said, if you go too far in that direction, the judge is going to see through it and get irritated and bring the hammer down effectively. The judge is not an idiot. That's been made very clear. And so anyway, the deposition will be sealed, but Deaton says that certain parts of it will be released to the public at an unknown point in time, and this is because they'll need to review all the data to be sure that nothing is released to the public that should remain confidential. And so who knows when that would happen? What if it's next year? What if it's 2 years from now? I don't know what the timeline would look like. I don't know if it'd be after full adjudication of the case or after a settlement. And so in the meantime, all we can do is just sit here and just kind of think logically, okay, if you're on Ripple's legal team, what might you be asking? Which is exactly what John Deaton has been speculating about. And he had some very insightful things to say, clearly. And so Deaton says Ripple's attorneys will want to run through the 2018 Ethereum speech, which again is what's on your screen right now, perhaps line by line, because putting Hinman in a position that's tough to defend could favor Ripple, right? And so let's go through some specifics of the speech. Check this out. I don't know if I got like 5 or 6 of these things, something like that. But here's one that John Deaton highlighted. I saw this in an interview. And where was it? It was yeah, here we go. So the quote is, this is from William Hinman's speech. This event provides a great opportunity to address a topic that is the subject of considerable debate in the press and in the crypto community. Whether a digital asset offered as a security can, over time, become something other than a security. And that's, by the way, to be clear, that's right at the very top. That's like the third sentence of the speech. And so, even just take this sentence, which, again, at the very beginning of the speech, you're going to want to read that and then get Hinman to admit that he gave the speech because there was confusion in the marketplace. This is the point that John Deaton brought up. There was confusion. That's why he gave this, and the SEC is pretending today there's not confusion. And so, what is a security? What is not? This is key to Ripple's fair notice defense. And so the fair notice defense is this idea that Ripple, having operated transparently in broad daylight for the better part of a decade, they did not have fair notice from the SEC that what they were doing was perceived as illegal. And so if the court finds that to be the case, that Ripple didn't have fair notice, Ripple, like, the whole thing's over. Ripple wins. It's done. That's it. That's how this works. And that's why this is such an important defense. This defense has serious teeth to it, right? And so that's why this is all important, because with William Hinman here, again, this is one of the top high profile, whatever you want to call it, individuals at the SEC, a high level, high ranking, whatever you want to call it. He's at the top. There's almost nobody above him at the SEC. And so he's given a speech in 2018 clearly. I think we'd all agree on this. It's pretty obvious, because there wasn't clarity in 2018. There wasn't clarity. Yet the SEC is claiming that there was clarity the whole time. And so, fine. So they like to argue, like, okay, this is just William Hinman's opinion, not the official position of the SEC. They always love to say that. But he's one of the top people at the SEC. And then you've got Hester Peirce and Elad Roisman, who clearly, they made it very clear, they share that opinion as well. And so if you're just thinking about a person of average intelligence, how are market participants supposed to actually feel confident in what the SEC, how the SEC is going to treat the space? Of course, none of what's happening here in this case is logical. You and I know that. I think the SEC knows it, but they're seeing what they can get away with. It's a money grab and or power grab. That's what it looks like to me. And so anyway, if there were not confusion, there would be no need to give the speech in the first place. If there were no confusion, why is Hinman saying any of this stuff? And so this is an example of the idea of using Hinman as a witness for Ripple, right? Exactly. And so even if the judge buys the idea that this is not the SEC's official position, like, this all adds up. These are high-ranking SEC officials: Hester Peirce, Elad Roisman, William Hinman, and so that's why Deaton was saying this is why Hinman could be the basically a star witness for Ripple. Here's another quote from the speech. To start, we should frame the question differently and focus not on the digital asset itself, but on the circumstances surrounding the digital asset and the manner in which it is sold. There you go. That's the quote. Which we already know. It's just like when you go back to, like, the Howey case, were oranges securities, or is it the way in which the orange groves and the whole deal was packaged that was the security, or was it the underlying oranges? Well, of course it's not the oranges. So apply that to what's happening with XRP specifically. How can XRP be a security? Can it just be, if anything, the way in which it was packaged and sold? That's different. That is functionally different. So the SEC is claiming that sales of XRP, including sales within secondary markets, are representations of an investment contract with Ripple, which means XRP itself is a security. And so if you ask the SEC, and they have been asked, it's been brought up in pretrial hearings, like, if is the XRP sold by people in secondary markets, like, people like you and me, just retail speculators, are those transactions of securities? And so they like to say that the answer is no, but if you look at the wording within the legal complaint that they brought, they clearly state that just sales, including in secondary markets where you and I participate, we buy and sell XRP, those are representations of an investment contract with Ripple. They're arguing it is, while saying to a judge it is not. They're speaking out of both sides of their mouth, guys. That's what they're doing here. And so that's something that's that's really legally never been argued before, that the underlying asset itself is a security. This hasn't been argued before, but the SEC is doing this now. And so yet here's Hinman stating in 2018 that such an approach doesn't make sense. So you could get Hinman to admit that XRP itself is not a security. That's important. And so then there's another quote. Unfortunately, this is from Hinman's speech. Unfortunately, there also are cases of fraud. In many regards, it is still early days, end quote. And so here, John Deaton says Ripple's lawyers will want to get Hinman to admit that the SEC didn't go after Ripple back then. One of the reasons is because there was no fraud and because there was no XRP ICO. And obviously, the SEC made it very clear that they were going to go after ICOs in 2017, and they did, yet they left Ripple unscathed at that point in time. How irresponsible could the SEC possibly be if they're really harming investors to the tune of over $1 billion in XRP sales? Why would you let them just act in that way unchecked for almost a decade? That doesn't make logical sense. Of course it doesn't. And so then here's another quote from the speech. But in many cases, the economic substance is the same as a conventional securities offering. Funds are raised with the expectation that the promoters will build their system and investors can earn a return on the instrument, usually by selling their tokens in the secondary market once the promoters create something of value with the proceeds and the value of the digital enterprise increases, end quote. And so John Deaton says this sounds exactly like Ethereum. Ethereum co-founders raised $18 million from 9,000 people around the world in 2014, before Ethereum existed. This is an ICO, my friends. This is an ICO. That term didn't exist back then, but what we call an ICO today, that fits it. That is the definition of an ICO. Absolutely it is. And so you can't say the same about Ripple and XRP. XRP was fully functional before Ripple even existed. The judge needs to see these arguments because what's happening here is clearly selective enforcement. And so the judge, being unbiased, will see it doesn't make sense that Ethereum got a free pass from the SEC. Deaton has pointed out that Ethereum, and I love this, check this out. Deaton pointed out that Ethereum satisfies the Howey test better than Howey satisfies the Howey test. In fact, in the original Howey case, one of the Supreme Court justices had a dissenting opinion and said some people did go to the orange groves to pick their own oranges and sell them. So for them, there was no investment contract. You can't make an equivalent claim with Ethereum. So Ethereum really does satisfy Howey better than Howey satisfies Howey. Yet it got a pass, and the SEC went after XRP, for which there is no common enterprise. It's astonishing. Here's another quote from the piece. And putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transactions. And so this thing's always bothered me. And putting aside the fundraising that accompanied the creation of Ether, no. Why are we putting that aside? That's highly relevant. You're talking about an ICO. Those early days transactions should absolutely have been addressed if you want to distribute justice equally. But that isn't what the SEC wants to do, is it? And so, yes, at some point, Ethereum became sufficiently decentralized. There's not a common enterprise anymore. All sorts of different developers building on top of the blockchain, where you can make a strong case that, yeah, of course, it no longer looks like it's being sold as a security. Of course you can make that case. But in the beginning, no. It was arguably centralized, frankly. And so, Deaton says Ripple's attorney should ask Hinman, what Hinman learned that gave him the understanding that Ethereum is not a security. Because again, he says it's just his opinion. So what did you learn that gave you this understanding that Ethereum is not a security? Did you compare Ethereum technology to any other technology? If Hinman defends Ethereum as decentralized and thus not a security, Ripple can use that to defend its position and XRP specifically. And so the fact that the SEC never came out with an official statement opposing anything from Hinman's speech is very telling too. If they had a serious disagreement, then they would need to address that, given that Hinman was a high-ranking SEC employee. And think about it, then he was all over the news on CNBC sharing his opinion, using the words "we," referencing the SEC, even though he's now pretending like it's just his opinions. And so the SEC was perfectly fine with Hinman presenting this as an official SEC position, even though now they're claiming that's not the case. And so it's completely ridiculous. But I'm just telling you, you compare what was cited here, and think about this, like, if this isn't the SEC's position, like, what the hell kind of confusion are you adding to the marketplace by allowing something like this? But if you take a look at the specifics in the speech and compare it to technologically, like, what is XRP today and what was it back upon inception, it's very clear that it makes no sense to consider at least that today's XRP is a security. It makes no sense in the world here. And so, look, unfortunately, we're not going to, like I said, we're not going to know what happens behind the closed doors today. Well, at some point, at some unknown time in the future, probably, based on what John Deaton says anyway, get some quotes from it. Probably, I don't know if it's going to be less than half or more than half. I don't know how much is going to come out. We'll probably get something, but we don't know when. And so that's why I really value the fact that John Deaton has taken so much time to share publicly his opinion on what's likely to go down here, because unfortunately we're not going to get to hear it for ourselves. But this is useful. Just getting opinion from an actual attorney on like the approach you take, because this is not stuff that I not having a background in law at all. This is not stuff that I would have been able to think up on my own. But you can tell that the way that John Deaton's going here, and there are a lot of ways that you could, if you're Ripple, seriously benefit from having William Hinman under oath today. So we shall see how this unfolds, but I'm assuming whatever happens here, more likely than not, will be a net plus for Ripple. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.